We are recording.
All right, thank you, Madam Court Monitor. Good afternoon, everyone. The Appellate Court for the State of Connecticut is now back in session. We will now hear the matter of Allen versus Shops at Buckland Hills, LLC, AC 42828. I am Judge Mall. I have the pleasure of sitting this afternoon with Judge Cradle and Judge Clark. Because we are still in the midst of a pandemic, we are conducting this hearing virtually using the Microsoft Teams platform. Before I have everyone state their appearance for the record, let me alert or otherwise remind everyone that this argument is being live streamed on the Judicial Branch's YouTube channel. Accordingly, to the extent that this case involves any protected identifying information that should not be disclosed, you are reminded not to disclose such information during the argument. I would now ask that everyone participating in this hearing identify themselves for the record, starting with the judges, then counsel for the appellant, then counsel for the appellee. Again, I am Judge Mall.
I'm Judge Cradle.
Good afternoon, Judge Clark.
Good afternoon, Your Honors. Mario Cerami for Officer Charles Allen, the plaintiff and appellant.
Good afternoon, Your Honors. Eric Niederer from Wilson-Elser on behalf of the defendants and appellees, Shops at Buckland Hills, LLC, and Allied Barton Security Services, LLC.
Right, counsel, prior to this proceeding, you should have received procedural instructions. Do you have any questions about those instructions?
None come to mind, Your Honor.
No, Your Honor.
All right, a few additional preliminaries. When you are not speaking, please remember to keep your video on, but mute your microphone. We have found that that helps with avoiding some of that audio feedback with which you are certainly familiar. But make sure you leave your video on. We want to ensure that we don't lose anyone. Also, let me state the obvious. Conduct yourselves accordingly as though we were in the physical courtroom, even though this proceeding is being conducted virtually. Kindly conduct yourself as though we were in the physical courtroom so as not to create any distractions for the court or for opposing counsel. Each side will be permitted 20 minutes of argument. The appellant, of course, will be permitted to reserve a portion of the 20 minutes for rebuttal. Just let me know if you wish to do so. So, counsel, are you ready to proceed?
I am, Your Honor.
All right, you may do so.
I'd like to reserve 8 minutes for rebuttal.
All right, that's fine. Go ahead.
All right. Before I begin, before I address the court's questions, there's 3 pieces that if I don't get to right now, I will never get to. I need to make a correction to the appendix, and I just want to note it for FTR. That the last 3 lines of the table of contents in the appendix should indicate that the transcript for 12-13-18 begins at A156, that the transcript for 12-17-18 begins at A171, and that General Statutes 54-1F is at A173. We had some technical difficulties with assembling the appendix, and I just needed to say that for the record. I wanted to address 2 more pieces. Their facts, there's a particular fact I wanted to address from them, and I wanted to note something in particular from Snell vis-a-vis the instruction that was given in this case. As to their facts, on page 2 and page 9 of their brief, they use this fact saying that Officer Allen locked eyes with the driver of the vehicle. And this was a problem for me during trial, and I looked through the transcripts very carefully. They cite generally to transcript citations to the transcript of 12-4-18 to pages 70 through 75. They didn't include that transcript portion from what I could tell in their appendix, but I reviewed it, and I could not find that word there anywhere in that section or anywhere in the day. And that just for if someone has to go through the breadcrumbs and look at what Officer Allen said about what he saw the driver of the vehicle do, I just want to note that some of the relevant pages, page A108 of our appendix, that's page 40 of the 1130 transcript, pages A116 through A117 of our appendix. Those are what have Officer Allen on direct there testifies in great detail as to what he saw. On on the 12-4 transcript, which I don't think is in anyone's appendix, but of course we've included it. The relevant pages are 77, 78, 86, and 101. And again, I wanted to get this in, I wanted to get that on the record in case someone has to go back and do some really close reading. As to Snell, I want to note that the judge in this case couldn't have adhered to Snell because it was not yet decided. So he couldn't have incorporated that into his judgment or his ruling on the instruction. There's on page 4 of our brief, I recite the relevant instruction. And I just want to read some language from that instruction and compare it again to some language in Snell. The language in the instruction was, due to such superseding cause, the defendants did not legally cause the injury, even though their negligence was a substantial factor in bringing the injury about. That's the instruction that was given in this case. So even if there was a substantial factor in the negligence of the defendant in this case, the superseding cause would mean that it did not legally cause the injury. That's the instruction that was given in this case. It's on page 4 of our brief. We cite it. It's in the transcript of December 13, 18 at page 132. I wanted to compare that to the text in Snell at the bottom of 753 onto 754 in that case. And the instruction or the ruling in Snell was the defendant's conduct was not a substantial factor in producing the injury and thus was not a proximate cause of that injury. So in here, if it wasn't a substantial factor in the instruction here, even if it wasn't a substantial factor, they were still forgiven. Whereas the holding in Snell is, if it's a substantial factor, then it's part of the proximate cause. You don't get to have a superseding cause.
Counselor,
if it's not.
Did you brief this issue at all? Because I read Snell right before the argument, so I'm very familiar with it. It's fresh in my mind. I understand what it said. I was going to ask some questions, frankly, about the absence of any sort of verdict on the interrogatory with respect to the security company in light of Snell. But the argument you're making now with respect to the instruction and what it said about the negligence of the actual defendant and whether that's even possible in a case of an affirmative defense of superseding clause, which was the issue of Snell, I don't find that anywhere in your briefs.
Judge Clark, you're right. So there was some sharp practice around deadlines in this case, and we had to do some last-minute cuts, and I did not intend for this section to be cut, but it was. So you're right. I didn't. I intended to have this argument included, and it wasn't. But you're right. I did not. And so I am. But you
obviously didn't raise it at trial because Snell hadn't yet been decided anyway, right?
We couldn't have raised it at trial. That's right. We made arguments along a similar vein. You can see there's a colloquy with Judge Graham, and I don't have the pagination right off the top of my head, but there's an extensive colloquy where we preserve the error, and I believe it's during where we refer to what happened during the charging conference. And there we discussed this issue to some degree. He pushes back and says, are you essentially saying that there is no proximate cause under this? And so there was some discussion as to around Barry, really it was at the time. Right. But the point's well taken, Your Honor. I think that I would note that the court has to look at the instruction as a whole. And I would say that this is part of looking at the instruction as a whole, but the point is well taken, Your Honor. I really do want to address the court's questions because those are the most important things I can do today.
Well, I mean, why don't you, it seems to me the thrust of your argument, there's many pieces, but the main thrust seems to be around this question about the inclusion in the charge on the special defense of criminal conduct and the question that the judge received from the jury. What would you like us to know about your view on that?
Well, I think I hope I outlined it fairly clearly in the briefs, but you can't just assume that the jury kind of knows what a crime is.
So, Counselor, was there any evidence other than what evidence did they have with respect to criminal conduct? Was it just the arrest warrant that was?
I don't think a warrant issued, actually. I think there was just an arrest. I don't think the warrant can be substantiated on probable cause because Officer Allen couldn't positively identify the driver.
Okay. So there was no conviction and there was no evidence of any conviction before the jury, right?
Right.
Okay.
Right.
So is it your view that when a defendant introduces the defense of a superseding clause and wants the charge to include not just intentional but criminal conduct, that essentially you have to have a mini trial in the civil case about whether or not a third party that's not even a part of the case actually committed a crime? I mean, that seems to be a rather unruly way of conducting civil cases. But what is your perspective on when that's an appropriate charge and what needs to be proven?
It's a lot easier when there is a conviction, right? And I don't know whether there was a conviction in Snell, but we had criminal conduct there, reckless conduct in there, and it was somebody held that it was criminally reckless conduct. And I think the burden of proof is different too. They only have to show it was more likely than not, right? They claim the defense, so they own the burden. And they don't have to show, a conviction. They don't necessarily have to get a conviction. It just has to be more likely than not that it was criminal conduct. And along attending to the other pieces relative to Snell and the superseding conduct.
So your argument is if there is no conviction and that conviction isn't presented, therefore, to the jury, but the charge nevertheless includes not just intentional but criminal conduct, then it is in fact incumbent upon the defendant to, by preponderance of the evidence, prove to a jury that the intervening conduct was in fact criminal. And in order for that to happen, the judge needs to instruct the jury on the elements of the crime. That's essentially your argument, right?
Yes, Your Honor. And I would also point out, because harm is an important piece here too, that the defendants argued assault 2. And I point out 4 times in the transcript where they allege that assault 2, that's a felony in closing argument. So it's not, this was just some idle spinning, counting angels on the head of a pin argument. This was part of their argument, and it's an important part of it. And the jury, as the court I'm sure knows, the note from the jury was directly to this issue on whether this was criminal conduct or not. So,
well, actually, what they asked a hypothetical question. They asked the judge, had this third party in fact been convicted of a crime, could the case have proceeded? Which is kind of a little difficult to understand what they're asking. And the judge basically said, it's not appropriate for me to answer hypotheticals. Isn't that what happened?
That's correct, Your Honor.
All right.
But they clearly had a question about, we're talking not about some civil piece, we're talking about something criminal.
What are we to make of that question, though? I mean, on the one hand, I guess, what's your argument about the import of that question? That in fact, they were struggling with whether or not the defendant had proved that there was a criminal act, or, I mean, alternatively, I suppose one could argue that, they were basically giving up on the idea that a criminal act had happened because they were certainly aware that there had been no conviction. That seems to, so with respect to whether, and which frankly goes to the question of harm, doesn't it?
I was following His Honor until the very end. And then,
well, at the end of the day, what are we supposed to make of that question, and how are we supposed to decide whether or not there was harm? And there's no question that I think, at least in my view, there was ample evidence to support the notion that the act was intentional. Right. And usually in these cases, the focus is more on, the causation question as opposed to whether or not it was intentional.
Right, Your Honor. So there's 2 pieces to it. I see I only have about 45 seconds left, but I would point out that the standard here is whether there's a reasonable probability that the jury was misled on the law, right? It's like essentially probable cause. If there's a reasonable probability, and I think we have that here, we have evidence of a reasonable probability that the jury was misled on the law. And the other piece is, although, there's a presumption, a fairly strong presumption that the jury follows the instructions. Here, we have something that rebuts that they clearly were struggling with understanding the instructions, which were on their face not okay with the law, but they struggled with it. So I believe that presumption is called into question, and this is sufficient to rebut that presumption. I see I'm almost out of time. I would save the balance of my time if there are no further questions, but I'm happy to address any others.
All right. Attorney Niederer, you may proceed.
Yes, thank you, Your Honors. I want to address each of the three issues that were presented by the appellant in this case, but I do want to discuss Your Honor's last question with regards to the jury question. The case law is quite clear that it's not the role of the attorneys or this court to theorize or hypothesize what was in the minds of the jury with respect to that jury question. And I know the appellant is trying to raise that to color the issue with respect to whether or not this jury understood the law and whether there was harm in the instruction. Really what their question, if we're going to hypothesize, which we shouldn't, is why are we here? Because to the other issue that was raised by Your Honor about the evidence of criminality, there was not just the arrest warrant that was a full exhibit, but the entire investigative file. Two Manchester investigating police officers testified with regards to their investigation, probable cause, and application for a warrant. The only thing that stopped them from arresting Mr. Champion was that the plaintiff ultimately said he could not provide a sufficient identification, despite the fact that later, assuming there was a good faith pleading, brought a civil action against Mr. Champion arising from this incident. So you also have the plaintiff's testimony with regards to the occurrence. You have the surveillance video. There was replete evidence throughout this case of criminal activity. But as Your Honor pointed out, when we're asking questions about the jury question, they could have easily found intentional conduct even if they did not find criminal conduct. So this jury question is an absolute red herring.
Well, can I just ask a question? I mean, so you clearly put before the jury and even in your closing argued this point that not only was there ample evidence of intentional conduct, but they could also, when you urged them to find that there was criminal conduct. And then I think your counterpart actually asked the court to include in its instruction some information for the jury to understand the elements of whatever crime it is that you would have them believe had been committed. And didn't you object to that charge?
Well, Your Honor, I think the record is conflated on two issues. One is if you look at the plaintiff's appendix A38, where that was the plaintiff appellant's request to charge as to superseding causation. They did not ask for an instruction on the elements or what constitutes criminal acts. Where I think Your Honor is raising this, and I think it's because the appellant confused the issue in their brief. So certainly I don't think it's Your Honor. They raised it in their brief. But that was with regards to request to charge on Connecticut General Statutes 54-1F, which goes, and that was in conjunction with and in line with the comparative negligence in whether or not this, at the time, municipal police officer exceeded his scope to decide on his own without request.
Let me ask you a question. What was in the jurors' possession that would possibly permit them to conclude that a crime was committed? I mean, was there anything within the warrant or any of the investigative files that included what the elements are of the crimes with which they were charged?
Yes, Your Honor. There were statements. In fact, there were two statements. The plaintiff himself made a statement to police and then came back and made another statement that was contained in the warrant application and in the investigative file. That was a full exhibit that went into the jury box with the jury.
But did those materials lay out what one would have to prove in order to convict someone of the particular crimes that were apparently listed in the warrant? I mean, so because that's what they wanted in the charge. And my question is, was that information in their possession absent the charge somewhere?
Yes, Your Honor. In my closing argument, I didn't come up with assault 2 because I'm a criminal defense lawyer. I've never acted as a criminal defense lawyer in my career. That was from the evidence that was submitted to the jury. And the arrest warrant laid out the elements and the evidence to support that. In addition to,
is that anywhere in the appendix? Where can I find the materials that you claim would inform the jury about what the elements of assault 2 are?
Yeah, I do not believe it's in the Appendix appendix, Your Honor. I believe that's there's evidence of that within the record itself.
All right. Okay.
Yes.
And do you think that what if there weren't? I mean,
well, to go to Your Honor's point earlier, we can't guess or hypothesize what the jury found. They found an intentional act, and there was replete evidence, and including even in the plaintiff's brief, they admit that there's evidence of the act. They simply say the charge was deficient because it did not lay out the elements. They don't even argue that there was insufficient evidence of a criminal act if you read their own brief. So to point to Your Honor, the record is replete with not only criminal conduct, but if we want to eliminate the criminal conduct issue, it's absolutely replete with intentional conduct that would satisfy the Snell decision, Sullivan, and Berry.
I guess the appellant's view is that we don't know which one they found, and if they found criminal, there's a serious chance that they may have gotten that wrong if they weren't properly instructed on what the elements of the crime are. I mean, that's the problem, right? I mean, we didn't have an interrogatory that broke it out to say, do you find intentional? Do you find criminal? And so I guess that's your opponent's argument, is that we don't really know whether they found, based on criminal, and just kind of guessed as to what the elements were. And that's where it becomes problematic, I guess.
Yeah, well, it becomes problematic for the appellant because in order to be successful, again, the law is extremely clear that we are not to guess what happened in the jury deliberation room. They were clear. So getting to the Snell issue, the only issue with regards to Snell is that they uphold the superseding causation defense on both intentional and criminal conduct. But in that case, the sole reason it was remanded, because I've read that case multiple times, and Your Honor, I know you said you read this right before oral argument, was that there was a divergence in what the jury found, because the jury found negligence and proximate cause as to the alleged tortfeasor, and then also found superseding causation. And in this case, that did not happen. We had a very sophisticated jury that did not find negligence or proximate cause, and then went to superseding cause and said, there's clear evidence of superseding cause, therefore we cannot find proximate cause. And that's what I think you alluded to earlier, Your Honor, about why that first interrogatory was left blank, because negligence and proximate cause was part of that first interrogatory. And we had a very sophisticated jury. They were very educated. They had great academics. They were thoughtful and paid attention to the evidence. It was an extremely great experience to know that these people did their duty, and they did it well.
I guess the problem is that the problem that the appellant points to is that we don't know. We don't know whether the jury, if they had checked the box, that maybe they would have done what the jury did in Snell and checked yes. I mean, if they had checked no, we clearly have no problem. I think it's the absence of checking either box that the appellant is saying at least raises the specter of a Snell problem here, right?
I don't believe it does, Your Honor, and here's why. Because if the jury came back with a jury interrogatory saying, we want to check box 1, finding proximate cause, but we don't know how to reconcile that with the superseding cause, then I think we'd have a Snell problem. Here, we don't have a Snell problem because they found superseding cause and they did not find proximate cause. And if you think the most logical, rational decision is, if you find superseding cause, you can't find proximate cause. That's exactly what this jury did, contrary to what the jury did in Snell. So respectfully, Your Honor, we don't have a Snell problem here. We have what should have happened in Snell However, assuming the jury found that way, and clearly in Snell, they found something differently. Again, we could hypothesize, but the law doesn't allow us to. But if we hypothesize, the Snell jury could have been confused. They could have found both proximate cause and then erroneously found superseding cause. They could have found superseding cause and thought, well, I don't really understand proximate cause as it relates to superseding cause. So we're just going to check that box off because they were in the causal chain, even though it's severed with the. But again, these are all hypotheticals, even with the Snell decision. And that's why, because you have inherently conflicting determination by a jury, the Supreme Court of Connecticut had to remand that case. Again, that did not happen in this case. We do not have a Snell issue. Yeah, I didn't know if there were any other questions. I can continue with the other points. Okay. I touched upon it a little bit with regards to 54-1F, which goes to the plaintiff's conduct while he was a municipal police officer. Judge Graham, who was the trial judge, spent a lot of time, as you could see from the appendix and the record. There was substantial evidence and discussion about this, but this is a red herring because the jury never got to proximate cause based on negligence as it relates to Allied Barton. Again, they found no negligence, no proximate cause as to Buckland Hills. But as it relates to Allied Barton, there was never, they never got to the issue of comparative negligence on a comparative negligence theory as it relates to the plaintiff's conduct. And that's where not only that statute was, and the charge on that was in conjunction with the proximate cause charge in that case, it directly related to duties of care as it relates to the plaintiff. 54-1F was a full exhibit that went in. So where the plaintiff cites in his brief that there was not sufficient charge as to 54-1F, that went in with the jury by agreement of all counsel, all parties. So they had the law with them. As it relates to a premises defect claim, as I indicated during the charge conference, and I'll reiterate this, and I had another trial on a similar issue where a plaintiff was looking at a premises liability action on a simple negligence case like this one before another judge. And what I'll tell you is this, and it was the same discussion that we had with Judge Graham, and fortunately Judge Graham got it. There's no defect. In fact, brother counsel started arguing the Kelly versus Stop and Shop case, which we all know is a mode of operation case and a slip and fall at a salad bar. That's not the scenario here. And the question was, and I asked it, and then Judge Graham asked it, what's the defect? Where's the notice? How do you remedy? How do you warn against? And Judge Graham even said, and it's in the appendix, do they need to put a sign up that says there could be shoplifters, there could be people running through the parking lot, and there's a duty to warn? This is not a premises defect case, and not just this judge, but other judges in the same court has consistently ruled where there's not a premises defect, it's inapplicable. And the other issue is, and we didn't ask for the fireman's rule charge, specifically because if your honors are familiar with that charge, it's that there's a heightened standard if there's a premises defect where someone acting under the color of law, in this case, a police officer, and the firefighters rule cites specifically firefighters and police officers, there's a heightened standard. This plaintiff would not be a business invitee. The standard is that it would have to be willful conduct. I'm sorry. So this is under the Lewandowski versus Cohn case, 267 Con 651 2004 decision. Thus, under the firefighter's rule, the landowner generally owes the firefighter or police officer injured on his property only the duty not to injure him willfully or wantonly. So if there was a premises liability charge, which would have been inapplicable in this case. But had it been granted, we would have gotten the charge that it would have had to been willful or wanton conduct by my clients. And I can guess the plaintiff would not have wanted that heightened standard. It's inapplicable. The whole appeal issue with regards to a premises liability charge is completely erroneous. It's a red herring. I don't know if there's any further questions, but I think I've covered the majority of what I wanted to cover. All three of the issues raised by the appellant has no basis in the issues of this case or the evidence of this case. Quite frankly, we see it as just another bite at the apple. They don't like the result. We had a very sophisticated jury. We can't speculate or guess what they did in the jury box, but it's clear they knew what they were doing. They followed the law. They followed the instruction. We don't have a Snell scenario, and their determination of the facts and application of law should stand, Your Honor. Otherwise, we rest on our brief.
If I could just ask a quick question. What was
Yes.
the purpose of the 54-1F charge and who sought it?
Yeah, so I believe I raised that initially, Your Honor. And the reason that I raised that is because as we argued in our brief, it was hotly disputed whether or not this municipal police officer outside of his jurisdiction was acting under the color of law and with authority to act. He alleged that he was mandated to do that. And they also presented evidence.
But my question is, why was that material to the issues in the case? Was it a contributory negligence type theory?
Yes,
Okay.
and that's where that statute fell in the charge to the jury.
And your point is that that's harmless error because it wouldn't have mattered because the jury found there was a superseding cause anyway.
Two issues: one, that it was not erroneous, but
Right.
two, even if it was, it's harmless error. Yes,
Right.
Your Honor.
Okay.
All right. Seeing no other questions, we'll go to Attorney Cerami for rebuttal. Counselor, you have 8 minutes for rebuttal. If you could begin your remarks by addressing Attorney Niederer's argument concerning the firefighter's role. All right, you're on mute, Counselor.
Sure. We're talking about the premises liability issue.
Correct.
We weren't even instructed about the premises liability piece. So we would say, to begin with, the jury couldn't have known about premises liability or made a proper ruling on firefighter rule or any rule because the issue of premises liability was completely disincluded. It is true that, and the firefighter doctrine it applies when somebody's acting in the scope of their duties. They have, like when the firefighter shows up at your house to put out the fire, that's the kind of context it comes up in. It's not the kind of context like this where you have a business invitee, you have somebody who's buying sneakers and books as a business invitee. That's different from the duty of care owed to people who are emergency personnel showing up to save your house from burning down. I hope that answers Her Honor's question. I hope that addresses Her Honor's question.
Summarize your position as to how this is a premises liability case.
If it's foreseeable, if the owner of a premises who or the holder of land who has a business invitee come, and it's foreseeable that their conduct, the conduct of their agents or their employees, can cause harm of the kind of harm that the individual suffered in this case, or the individual suffers, the plaintiff suffers, then they are liable and they have a duty to protect that individual. The premises liability doctrine applies. And here we have people running through a parking lot. And so it's foreseeable that, and they're doing so against their own policies. They're running through the parking lot in violation of their own policies. They have a duty, special duty to business invitees that applies here because they are the holder of land to business invitee who is my client, and it's foreseeable that police are going to shop there. Off-duty police officers are going to be there. That's why they have consulted with security agencies and so on. And so I hope that addresses Her Honor's question.
Well, Counselor, I'm reading your brief. You basically seem to be saying that the heightened duty applies to any landowner who has business invitees, irrespective of whether or not it's a premises defect case. But I don't see any law to support that. You don't seem to brief it. You just kind of say it. It's on page 13 through 14 of your brief.
I didn't cite the sexual assault cases in the parking lot.
If you did, I'm just not seeing them here at that.
I'm sorry, Your Honor. I would happily provide a letter of supplemental authority afterwards, but there are several cases. There's one out in New Haven, and I cited them before the trial court too. I cited them in our arguments for motions for new trial and so on. There were premises liability where an individual was sexually assaulted in a parking lot. One was in a parking garage and one was in a parking lot, and premises liability doctrine applied. There were no warning signs and things of that nature.
Yeah, but that was based on the condition of the premises, though. You seem to be having a whole different theory of liability.
The issue was that it was foreseeable that that criminal conduct would occur
based on the condition of the premises. That's not what you. I don't
also
think that's
based
what
on the actions of the people who they control. That's another doctrine in there, and that comes from the Stop and Shop where somebody dropped something. It was foreseeable that someone would take that action. If the conduct of employees or agents is foreseeably going to cause that kind of harm, I believe that's the cases I'm talking about. It doesn't have to be an actual defect in property if it's foreseeable that the conduct of agents will cause this foreseeable harm to business invitees.
But that has nothing to do with the condition of the premises. That has to do with the operations of the business. So why are we even talking about this standard, which really applies in the context of premises liability and premises defect cases?
Because it also does apply to, because Your Honor, our position is, and I believe the case law holds, and the court may disagree, but it holds that, and we briefed this, but it applies to individuals, the conduct of agents of the holder of land too. If they do something, if their conduct is such that it's foreseeable to cause someone harm, or that it's foreseeable that it will result in criminal harm from a third party, foreseeable criminal harm from a third party, then they are liable for that.
Well, then it would apply everywhere and at all times, wouldn't it? Because, I mean, presumably anyone who has agents also has a piece of land where the agents are behaving in a certain way. And so it would swallow the rule, wouldn't it?
I assume the court's at 75 Elm. I don't know if His Honor's at 75 Elm, but I would be hard pressed to sue anybody, the holder of land at 75 Elm, for example. And it's not, I mean, Your Honor, it has to be foreseeable that their agents are doing this thing, right? For the holder of land's agents to be doing this thing. So I think there are limits on it. I think there are limits on it. I did want to say a few things in response to Attorney Niederer. You can't benefit from an argument that it was criminal 4 times in closing argument. You can't benefit from that argument and then say, well, they could have concluded it was intentional. That you don't get to do that. That's not fun. That's fundamentally not fair. You can't have your cake and eat it too that way. You can't rely on an incorrect instruction to show harmless error. You can't rely on an incorrect instruction to show harmless error. You can't rely on a warrant to instruct the jury on the law. The law, instructions on the law, the province of the judge and judge alone. You can't. I was accused of abandoning a claim relative sufficiency. Look, Your Honor, I pared down. We had 14 points of error. I'm not going to make a sufficiency argument if I can avoid it, because they're just really difficult kinds of arguments to make. Not because we were abandoning it or we thought that, something else was going on there. Look, are there any other questions from the court? I know I have almost out of time. Hearing none, I rely on our briefs for the rest of the matter. Thank you, Your Honors.
All right. Thank you, counsel, for participating in this virtual argument. The court will stand in recess. We'll take the matter under advisement. Court stands in recess until 3 p.m. Thank you.
Thank you.
Thank you, Your Honors.